From supplementary list, item 1, pronouncement of order.
The High Court in exercise of jurisdiction in a matter of this nature is required to determine at the outset as to whether a case has been made out for issuance of a writ of certiorari or a writ of quo warranto. This is what I'm quoting the judgment of the High Court of Gujarat. That is from Gujarat, it went to Supreme Court, 2003. Then, quoting the judgment, then referring to the judgment of the Supreme Court in Sri Ramakrishna Vidyaram High School, it is very lamentable state of affairs that in this country, a teacher who is considered as equal to God should fall from the high pedestal to the lowest level. Our scriptures command students to consider the teacher as God, Acharya Devabhava. The term Acharya in Sanskrit means who not only teaches lessons to students but also ensures good conduct of his people. The more important part of the definition is that he shall himself practice what he preaches. In Sanskrit language, the term Guru means a teacher. The syllable Guru, syllable Gu represents darkness, symbolizing ignorance. The Ru represents the removal of thereof. Thus, the Guru is so called as to a person who removes the darkness and ignorance from the minds of the students. In fact, there is a saying that it is only with the blessings of a teacher a person blossoms into a full man. Finding in the present petition, the benefit of particulars, PL is dismissed on the ground of maintainability as it is not maintainable in service matters. However, it is made clear that any appointment is made to the contrary to the rules, regulation, notification. There is no impediment to agitate by way of PAL for issuance of writ of quo warranto against such appointed. See, we refer to the Duryodhana case of the Supreme Court.
Item number 2.
Your Lordship, the arguing counsel in this instant matter is in bereavement. So is in bereavement. So 1 week time may be granted, Your Lordship.
Your junior on record.
Yes, Your Lordship.
What is the matter about?
Matter is about the gold biscuits which are in question. Where
oh, this is a case 4 kilos.
This is a different case. It's a new case. They have come by way of a writ petition, my lord, against the order passed by the tribunal. So, my lord, the question of maintainability, I'll file a small response to that.
So it is not maintainable.
They have to file an appeal. Well, what happened? They went to Rajasthan High Court, my lord, by way of writ petition, and that was pending there for quite some time. Now that has been
withdrawn,
my lord. That has been rejected, my lord, granting them liberty to approach this honorable court. That a lot of people find that. It's page 331.
331.
331. It was pending in Rajasthan High Court for almost 22 years, my lord.
Where is it, sir?
It was filed in 2002. Case 331, lordship says.
331.
My lord.
Yes.
The writ petition was filed in Rajasthan High Court in the year 2002, my lord. DB Civil Writ Petition number 1307.
Inner page 3.
331, my lord.
That is right. Page 331, inner page 3.
My lord.
Correct? Inner page 3.
But what I was trying to indicate, my lord, at page 331, lordship will see writ petition number is 1307 of 2002 on the top, my lord. Just after the High Court's name, my lord.
Pagination is not correct.
I think pagination is not correct.
It is in our page 329.
354, I think, page
385. Appeal number.
Given a different copy to me, my lord. Even her copy is not matching with my copy.
You cross-check the pages.
Yes, sir.
It doesn't tally. You have one page, we have one page, he is having one page. I think Junius was taught how to make the typeset of papers ready.
I'll rectify your lordship.
It's, I think 356. One 1307 of 2002.
The matter was pending there for 22 years, my lord. Now, by this order, this is which is 21/3/24.
So, according to which provision you got a right of appeal?
Well, I'll file a small reply. Well, in the meantime,
which provision we are asking? Para number 10 at page 364. You will approach the competent court jurisdiction.
well,
Court of competent jurisdiction. Shows the provision. You said the writ petition is not maintainable. Which provision? Appeal is maintainable.
Section 130 of the Customs Act.
$30.
130 was deleted by National Tax Tribunal Act 2005, my lord. But your lordship will see as it stood, my lord. It says, an appeal shall lie to the High Court from every order passed in appeal by the appellate tribunal on or after the 1st day of July 2003, not being an order relating to other things, to the determination of any question having a relation to the rate of duty of customs or to the value of goods for the purpose of assessment, if the High Court is satisfied that the case involves a substantial question of law.
Appeal shall lie to every order. This has been now it has been repealed.
My lord, the National Tax Tribunal Act has been stayed, my lord, by Madras High Court. So the original provisions are still existing, my lord. The original provisions of section 130 are still applicable because the act has been stayed by I think Madras High Court. Well, I'll examine all these aspects. I'll file a small response, my lord, within a week's time, about 10 days time, my lord.
16th.
16th.
The following week.
21st or 22nd?
Yes. Was on 30th or 31st?
Much
Of
appreciated.
the petitioner. Get ready with the matter. If your senior is not there in the next hearing, you must argue. If your senior is not there, you must argue the matter.
Yes, Your Lordship.
Item number 3.
My lord, this is an appeal against the order passed by the learned single judge, my lord. Here, what happened, my lord? Gold was seized by the customs authority, my lord, from Imphal airport in Manipur, my lord. Thereafter, what happened, my lord? At that point of time, there was a law and order situation in Manipur. Your lordship is aware. It was widely reported in media also. A lot of violence, communal violence, and internet were shut down. So, because of that, what happened, my lord? After carrying out the investigation, we were required to issue the so-called notice within 6 months, my lord. So 6 months was expiring on 3rd of October 23, my lord. 3rd October. So the letter was already signed on 3rd of October, my lord. But we could post it only when the curfew was relaxed on 5th of October, my lord.
So 2 days.
2 days, my lord. Now 110 of the Customs Act requires that if so-called notice is not issued within 6 months, the gold has to be released to the person from whom it is seized. Now, we tried to explain this before the learned single judge that because of extraordinary situation, my lord, curfew, shutdown of internet everywhere, my lord, there was a delay of 2 days, and these are not normal circumstances, my lord. Otherwise, we had completed
the order of the learned single judge,
my lord. Page 90, your lordship, and system.
90.
90, my lord. My lord, there was one more issue before the learned single judge, my lord. What happened, my lord? The so-called notice was signed by the additional commissioner who is located in Shillong, my lord. But the letter was posted from Manipur because the seizure and investigation was done by Manipur unit of customs, my lord.
When he signed it here, he should have posted it here.
It was posted from Manipur, my lord.
Why should he? He could have done it here. When the person has signed it in Shillong.
My lord, our procedure requires that, my lord, the investigating unit who is investigating, because the seizure is from Manipur, my lord, in this
case. The letter will have to be dispatched only from the investigating unit.
From the investigating unit.
How do you say that?
My lord, that we have said in our affidavit, my lord. But my lord, otherwise also a delay of only 2 days, my lord, because of the extraordinary circumstances in Manipur, my lord.
So outer time limit is 6 months or preferably within 6 months?
My lord, the section 110 of the Customs Act, my lord, if I may just point out, is quoted here also, my lord. At page 93, your lordship says, my lord. At page 93, section 110, my lord. Seizure of goods, documents and things, where any goods are seized under subsection 1 and no notice in respect thereof is given under clause A.
But was there any extension of time by the commissioner?
My lord, in this case there was no extension because investigation was completed and so-called was prepared, my lord. We did not seek any further extension of time. But the respondents are not represented, the notice has to be issued, my lord.
No, yes, we'll notice. You ask for a stay?
My lord. Because if you have to release, my lord, it will become impurchase.
My lord, you ask for a stay.
My lord.
Stay petition is not there?
My lord, interim prayer is here itself. My lord, page the lords. And this is page 15, my lord. Page 15, 1-5.
1-5.
The interim prayer, my lord, during the pendency of the.
You have to file a separate application for stay?
There is no standard, my lord. No? There is no such standard format, my lord, that stay.
No. In the High Court, you will have to file a separate petition. Otherwise, why should in other cases the application for stay is filed? See, you have filed it as if it is in the tribunal, in the Central Administrative Tribunal and the other places. There is no need for a separate affidavit. Insofar as waiver and other things are concerned, separate affidavit is there.
My lord. But interim prayer normally, my lord.
Administrative Tribunal, interim order can be sought for in the main application itself. That is how we have done it. But there is no miscellaneous application. Otherwise, why should we dispose of so many miscellaneous applications here?
My lord, normally in writ proceedings, my lord, we.
You have to.
Well,
otherwise, why should we close the series? The miscellaneous petition are closed. Then why do you want to file a separate application to condone the delay?
But
principle will apply there also.
Well, I'll file it by today itself, my lord. But if Lord permits the matter to be listed tomorrow, my lord, I'll file it today itself.
We'll file it tomorrow. Tomorrow. We wanted to grant interim order, but the application is not there.
Well, I thought the interim prayer, my lord, in any case, I'll file it.
Who is the local council here?
Be Dev, my lord. The arguing council came from Delhi, my lord. But the local council is there, but we couldn't find him. Well, what's your opinion? Tomorrow, my lord. I'll file the mistake.
Item number 4.
If you wanted to stay the order, possibly you give notice to the other side. Along with the stay application, you give them. Definitely they will take time.
Tomorrow.
If they take time also, we will ensure to grant the stay.
I will file it today, my lord. The marriage comes up tomorrow.
Item number 4.
May it please your Lordship. Lordship, I have received the paper book from the registry. I am appearing as a legal aid counsel in this matter. The matter is ready for hearing. It may be posted for hearing.
That is ready. You can argue now.
My Lord. It is a 302 matter, my Lord.
302, yes.
Yes, my Lord.
My Lord, we have not received the paper book. It is in the office. We will try to collect it, and thereafter, my Lord, it may be listed after a week, my Lord, for the final hearing. It must have been supplied, my Lord, but we have yet to collect it.
Only 302. Reason. Any other provisions?
No, my Lord. Only 302. Page number 103 of the paper book is the judgment.
103.
If your Lordship sees right at the top, session case number so and so under section 302 IPC.
What's the punishment?
Punishment life imprisonment, my Lord.
Life.
No, there is neither any intention nor motive.
Huh?
And there is no intention has been proved, motive or intention. And second thing, the statements of the witnesses are also not corroborating, my lord. Most of the witnesses are hearsay witnesses.
Have you admitted before the magistrate?
My lord, before the magistrate also, if my lord, I rely only on the statement given to the magistrate under 164. My lord, according to that statement also, intention cannot be proved anywhere. The 164 statement.
So, sudden provocation.
My lord, no sudden provocation. If I may take your lordship to the statement before the magistrate.
Where is the page?
Page number, my lord, it is the. My lord, page number 86. 86.
Yes.
Page 86, my lord. I reside at Madan Rawan with my wife Srimati Rikamenlang Lingdo and stepchildren. I beg to state that on the 10th of December 2011, I went to the market at Maukayao. I bought many foodstuffs. I also had drinks with my friends. As I reached home, I gave the thing which I had bought from the market to my wife. Then I also drank alcohol at home before dinner as ready. Then all of us sat down for dinner. After dinner, we went to sleep. I, along with my wife and 3-year-old stepson, slept on the floor, while the other children slept on the bed. My stepson was suffering from a boil infection. His mother, that is my wife, had breastfed him. My wife was sleeping with me and I don't remember what exactly happened. In my dreams, 3 men appeared and I ordered, combat them. I tried to strangle one of them. However, in my attempt of doing so, I didn't realize that I had strangled my stepson. I remember my wife waking me up and it was dark as I had extinguished the lamp. I searched for the matchbox and I got it from the floor. So I lightened up the lamp and afterwards my wife choked at the child and saw that he was not breathing anymore. He was dead. I also cried and realized that I had strangled my stepson.
What is the doctor's report about your the doctor?
My lord, the medical report says that the death was due to forceful twisting of the head.
That is right. You said suddenly 3 persons came in your dream and you wanted to strangle that person. Instead of strangling that person, you strangled the child.
My lord, if first thing, my lord, if we assume
we would like to know what is your mental condition. Whether you are subject to any examination by the doctor dealing with schizophrenia.
That part, my lord, I will have to check. So far as mental,
it's not there.
Mental checkup, my lord, I could not find any.
Actually, 84, you will be able 84. No, 84.
Defense.
Yeah, please.
So page 92 is the medical report of the accused person.
84. You are trying to bring the case on the 84.
Page 90.
Of a person of one's own mind. Section 84 of IPC. You are trying to bring that.
My lord, the medical report of the accused person is from page 92 onwards.
92. You are the stepfather.
Yes, my lord. And there were 5 children, my lord, not just one stepson.
Huh?
The wife, the accused's wife, had 5 children from the previous husband. So out of the 5 children, the deceased was the youngest child. And my lord, the statements, when we see the depositions given by the two main witnesses in this case are PW4 and PW5. The PW4 is the mother, my lord, and PW5 is the eldest sister of the deceased. Their statements are absolutely contradictory to each other, my lord. Nobody has seen strangulating.
Everything is normal.
Yes, my lord. Everything is normal according to this. That was the physical checkup, my lord. But so far as mental health is concerned, he was not sent.
So 84 may not apply. Then you are murdered the child.
Lord, even, my lord, if your lordship will kindly hear on the other aspects.
So according to you, you have not done it.
My lord, if we go by the statement under 164, at the most, this will not amount to a murder. It might amount to a culpable homicide not amounting to murder because there is no intention as per 164. And this 164 statement, my lord, was recorded by an executive magistrate, and the executive magistrate has stated in the deposition before the learned trial court that I do not know whether the accused person has given his statement under 164 under coercion or any undue influence. Because, my lord, the accused was sent for recording the statement under 164 while he was in police custody, not judicial custody, my lord.
Every time you are on alcohol, consumption of alcohol, we'll have to find out during which time you are normal. Sometimes people may say that by consumption of alcohol, it will be normal.
But the statements of the witnesses are material, my lord, especially PW 4 and 5. And the person who has lodged the FIR is the uncle of the deceased. He says, my lord, he stays 20 to 25 minutes away from the deceased person's house, walking distance.
What is this, sir?
My lord, after 10 days, my lord, we can come up fully prepared with the hearing.
Intention is there or not?
My lord, my lord, we'll have to go thoroughly to the.
See, you
records.
can't expect a man to kill a child wantonly.
My lord, it appears that it is a case of murder because the defense, there is nothing to prove on the man.
In Tamil, there is a saying, Kudi kudiyai kedukum. That is, kudi means drink. The same word kudi means a home. The drink will spoil the home, the atmosphere, and ruin the entire family. That is the meaning of that. So here, the child is dead.
Has become the
You
casualty.
will see whether the intention is there or not. Why not we bring it under the exception? Life. 10 years.
My lord, insofar as the prosecutions and our understanding is concerned, there is a proven case that he does not suffer from any mental.
That is right. Even before you started the argument, we have seen the provisions of section 84 and other things, and also the medical report. So that is in your favor, that you need not address. Only thing is whether the intention is there or not. There, an exception. Any of the provisions of life, you can restrict to 10 years or 14 years, whatever it is.
If I may just point out one more thing regarding the medical report, my lord. The FIR was lodged in December 2011, whereas the medical report is of, my lord, 28 November 2015. That is almost after a period of 4 years.
You are perfectly all right. That's all on that day. So definitely you are all right. So 5 years before also you were all right.
Lord, physically yes, but if a person is intoxicated, intoxication will also come in this matter because the accused himself is admitting that I was drinking. PW4, the daughter is also saying that he was drinking. The wife was also saying that he was drinking. And there was another friend who also says the same thing. So far as the drinking part is concerned, consumption of liquor, that
then
is...
we must blame the state also. The state is responsible for permitting sale of liquor. Yes. When will you be ready?
10 days, my lord.
If a date could be provided, my lord, I'll travel accordingly.
You are coming from Guwahati.
My lord.
Come. When do you want?
My lord, if a date
Last week of this month, last week of this month or
if it could be on
last week of June?
30th of May, my lord, if it is possible.
Yes. 33.
Will you oblige me? We'll come prepared.
So this is the only thing, nothing else.
Deeply obliged.
Don't think that we are going to acquit you. We are not going to do that. You try to argue for the reduction of punishment. That's all.
Item number 2.
Lordship, in this matter, I require 2 more weeks' time to file my objections.
What is this matter about?
This is a land compensation matter, my lord. 32 acres.
Matter when came up on a different district, different judge was nominated.
Yes, my lord. Yes.
We have filed the response. Lemon number 2 and 3 is pending for quite some time. I pray, let my friend file the response. In the meantime, Lordship may post the matter for hearing. Post the matter for hearing.
Yes.
My lord, I wanted to submit something. Here, the deputy collector or the district collector was supposed to determine the market value in accordance with Section 26 of the new Act, my lord, or the new. Now, the allegations here is somewhere coming towards her also that she has not properly determined the market value. Therefore, my lord, when we go on hearing, there would be some allegations against her. Now, she is not present before my lords. So, my lord,
She is also a respondent here.
she is of course not the respondent here, but because the determination is that whether the more amount was offered than what was more amount was paid than what was offered. So the duty cast was on the district collector to determine the market value.
My lord, the state used to represent. The state council used to represent on behalf of the collector. So they can represent also.
State may be implicated. The matter is pending from 2015. It was filed in 2017, then 2021.
Yes.
Then delay. Originally, it appears to have filed in 17. And one more round of litigation, 21 with delay.
Lordship, what happened in this matter, Lordship? During the course of my preparation to the response to the inquiry, Lordship, there are certain documents which are not in my possession, which are in possession of the registry, because there's a
So when do you want?
After 3 weeks, because I have to procure those documents as well.
So on to it at the request of. You're appealing for which respondent?
We, Lordship.
Who is representing? Who is representing the collector?
As of now, here there is no one.
No one.
But before the Honorable District Judge, collector was represented.
Yes.
Government was part. Collector is the party, you know.
Yes. Collector is a party.
He used to represent the collector.
Mr. Khan is there.
Yes.
On the earlier ground, we used to file the affidavit on behalf of the Deputy Commissioner Rigoy. So thereafter, when these proceedings initiated, my lord, we did not take much activity.
But it's a public under litigation. State is also a party.
We are there, my lord. If
Then you have to file your objections. You have to submit. See, when you're a party, then the PAL. You're a amicus, no?
Yes, my lord, I'm the amicus.
We'll collect the documents and
All of you will do that. You collect all the documents.
yes,
Yes. At the request of the state and R3. What was the matter? Sometime the last week of June or, last week of this month. Last week of this month? 30th or 31st?
Yes.
30, or you post it on Monday, madam. First Monday of June. 3rd June, huh? 3rd.
At the request of R2. I'm R3, he's R2.
Oh, you are appealing R2.
Yes, claimant number 2, R2.
The request of R2, sir, not R3.
My lord, I am for R2, and my friend is for R3. Senior is R4.
Oh, yes.
Sorry.
There are three rival claimants. I'm representing one of the claimants. Yes.
So, what is the name?
Patricia Nossi.
Your name? Party's name?
I'm an Patricia.
Patricia Nossi. Party's name. So and so. The request of counsel representing the request of the counsel representing so and so. Post the matter on 3rd June. And also the state. Request of the state and also the request of so and so. Yes.
Also, that liberty may be given to me so that I can apply the certified copy from the registry.
Why should we give? If you are entitled to, it will be given.
Item number 3.
May it please, Your Lordship. My Lord, on the last occasion, Your Lordship has raised certain queries, Your Lordship. I have, my Lord, obtained certain documents. In fact, it is my reply also.
What is the matter about, sir?
Matter relating to, my Lord, without having mining license lease, my Lord. Respondent number 7 is, my Lord, executing, my Lord, that mining of, my Lord, limestone, Your Lordship. My Lord, I have provided certain documents, Your Lordship, which will clarify, my Lord.
Where are the documents? No.
Is he giving the document right now?
Yes, he's placing. Now he is giving it across the bar.
It is part of my affidavit file, one of the document relating to the same.
Is it a new document? Is it a new document? The old document already on record?
On record, and this is in continuation of that document, which is filed in.
It's a new document. We have not.
New document now filing.
My Lord.
This is the new document. The senior is not having a copy.
My Lord, I brought, my Lord.
You brought, but you are not.
My Lord, because, my Lord, one document is.
The counsel from Delhi is addressing.
Guwahati, my Lord.
Guwahati, wherever it is. So you should have forwarded a copy.
My Lord, but the affidavit in my reply, it is in support of that only. Same.
That is right. You should have, if you had extracted this, it is not a problem.
My Lord.
If you have if you have reproduced the entire thing, that is right. If you have extracted some portion, you must read. You have to read the entire thing, is it not?
Since I am bringing this, Your Lordship, I am coming physically.
Give a copy.
My Lord. Otherwise, Your Lordship, if Your Lordship will see this document, which is supported by a reply filed by.
We are having it. We can see. Your friend will also see.
Through Your Lordship.
You'll have to see.
Can I?
Give him a copy. The counsel on record is here.
Yes.
Take a copy.
May I read, Your Lordship?
Yes.
What? What's the producer? One page document.
Mining leases of limestone in Jaintia Hills of Meghalaya.
Meghalaya. Clause B, Your Lordship will see the details of cement companies which have been given license for mining of limestone in Jaintia Hill. And sir, Your Lordship will see.
There are 21 companies.
My Lord.
Yes.
B and C.
Sometimes what do you want to say?
My Lord, the respondent number 7 has not been granted mining lease.
No, sir. Respondent?
Number 7 has not been granted mining lease for the purpose of mining limestone that I wanted to show before Your Lordship.
So you are concerned only about 7.
7, Your Lordship. And respondent number 7 is not there. Now, Your Lordship, may kindly come to page 286.
Is it a business rivalry?
No, my Lord.
Oh.
I have given all details affidavit, my Lord. I am not running any business, my Lord. I am not.
Before he
Any of your relative?
My Lord.
Any of your relative?
No, my Lord.
Or before filing this
I am
case?
76 years old, my Lord. And my Lord, I am not.
It is at the age of 76, you cannot run a business.
My Lord, I am not running. That statement I have given. Now, Your Lord, may kindly come to page 286.
286.
And date, Your Lordship will see 31st July 2023. And next page 287, my Lord, kindly see. 286.
Where is 286? You don't have.
This is the number given by court. Page 16 of my reply. My lord, page 287, my lord.
Annexure C, inner page 15, sir. Annexure C.
My lord, of their petition?
My reply. Affidavit in reply filed by petitioner. And page 287, my lord, kindly see.
So let him also go through it.
List of cement.
My lord, my lord, suggest one thing. The last occasion also, my lord, there was some problem with the pagination. And I have requested the person who is instructing me to see and note down, make the same page number in my copies so that when I'm making a reference to your lordships, there is no discrepancies. But this has not been done. Not a single paper that I have has been marked. So there will be difficulty for me to, my lord, answer to what he says. Besides that,
Mr. Mishra, 1 minute. So, who's the notes on record? Why don't you take the court paper and note down the pagination?
Well, do you?
So, junior must first take one typeset of paper, number it, and thereafter, from that, it has got to be xeroxed.
Lordship, because
These are all things you can learn when you join as senior. Otherwise, if you are going to take each one is going to number the typeset of papers, you will be doing only the clerical work, and the previous case, each one is having a one-page number.
Lordship, because the code itself has numbered.
From here, we cannot teach you. This is not our work. Or we will do the pagination work after 3.5 months after my retirement and come and assist you.
I have paginated after seeing court record. That's why.
Yes.
Last week.
On my lord, last occasion, on 14th,
today,
on 14th, my lord, he has not, my lord, told your lordship, submitted with your lordship the correct position of what transpired on the 14th. 14th, this case came up. I was arguing on preliminary objection that this PIL is not in accordance with PIL rules framed by the High Court of Meghalaya. Now, I have already placed.
Last time I argued.
My lord,
Yes. And during the let me finish. And during the course of the argument, my lord, Mr. Chief Justice asked him whether obtaining a mining license is condition precedent for establishing a cement factory. That is what he is trying to make out. And then my lord Chief Justice asked him to produce that requirement in law that unless you have a mining license, you cannot establish a cement factory. He's beating around the bush, my lord. I'm sorry to say that, but he has not been able to show any law on the point.
My lord, so far as my lord discrepancies in filing PIL as per the Meghalaya High Court rules, my lord, in my reply, I have clarified that there is nothing as suggested by my lord other side. Moreover, I have, my lord, supplied one decision of Honorable Jharkhand High Court, where the same question came up before Jharkhand High Court, whether some clauses are not being followed, whether the PIL will be maintainable or not. Jharkhand High Court, after going into the merit, my lord, came to the conclusion these technical things cannot take away the measure if the serious allegations are being made in the PIL. Another decision I have submitted before your lordship of Honorable Apex Court, where Apex Court in such a situation, if the corruption was pointed out, refer the matter to CBI for making a preliminary inquiry, your lordship. Your lordship asking me whether my lord cement companies without having mining license can mine limestone or not. In that support, I have submitted the document which is perhaps my learned friend has forwarded it to my learned senior also. My lord, all companies, 21 companies are having.
There has to be a hearing, my lord.
What does it mean, your lordship? If there is no requirement of mining, why the state has provided my lord mining license to those companies, your lordship? In fact, my lord, page 404, the reply says that cement companies cannot purchase limestone from outside. 404, my lord. What does it mean? They have used huge quantity of explosives, my lord, without having mining license, your lordship. Page 404, my lord. My page nation will be 133. Last page of my affidavit reply.
133.
133, otherwise the court page nation is 404. May I read, my lord? In continuation of the information furnished so-and-so, as per report, so-and-so has supplied limestone to Amrit Cement, respondent number 7, during year so-and-so, subject to royalty. Further, I am to clarify that after notification, the limestone being minor accrued from the mining lease area under so-and-so cannot be supplied to the cement companies. So, from 2012, my lord, they are running their cement companies. They have
last time he referred to some provision with regard to maintenance of the PL. What are the provisions?
Provision, my lord.
Yes, my lord, that's what I'm saying, your lordship. Your lordship will have to hear me on the maintainability. And the Jharkhand High Court decision that he is referring to was set aside by the Supreme Court, my lord, and placed before your lordship.
That judgment
was set aside.
That judgment is not, my lord. Supreme Court has entered into the merit of the case, your lordship.
Which
Jharkhand High Court decision.
Supreme Court has gone into the merits of
merits.
Yes, it has set aside.
Your lordship. This is the judgment of Supreme Court against the Jharkhand High Court decision which I have given. First, your lordship may kindly come to Jharkhand High Court decision, page para 109. Jharkhand High Court, it is report 2022 SCC online Jharkhand 1489, para 109, at page 32.
1489, yes.
Since page number 32, para number 109.
1 minute.
Jharkhand High Court.
Page number 32.
109 is the best.
At the top page number is
paragraph?
Para 109, 100 not 9.
109.
Yes, sir. Since objection number 1 and 2 are interlinked, they are taken up together to be answered by this court. Rule 4, 4A, 4B of Jharkhand High Court Rule Public Interest Litigation Rules, appended as Appendix 10 of the High Court Jharkhand Rules, has not been followed while filing the instant writ petition. Now, your lordship may, these are the objections. Your lordship may kindly come to now page para 116. 116. May I read, your lordship? After examining Supreme Court decision, Jharkhand High Court, it is thus evident that matters shall be treated as public interest litigation, which involves substantial public interest aimed at redressal of genuine public harm or public injury, and further to encourage only genuine and bona fide public interest litigation, and discourage public interest litigation filed for extraneous consideration. The bench hearing a public interest litigation.
According to you,
my lord,
we can give a go by to the rules framed by the Meghalaya High Court.
Those conditions.
Yeah. Is it pari materia with the Meghalaya rules?
My lord. Well, my learned friend, like I have not given the details.
My lord, may I?
Not given, my lord.
My lord,
we are asking a question. Is it a pari materia with the Meghalaya rules?
My lord, regarding my lord, bona fideness and all, in fact, in my reply, I have given entire details. What I am saying, there is no violation.
What do you mean with bona fides?
My lord, they are questioning my bona fideness.
No, we are not on that.
My lord.
We are not on that. We come to that later. Now, first maintainability.
My lord.
Then bona fideness.
My lord. My lord, so far as my lord.
See, even though you will have to come, assuming that we are going to take that you're having bona fide. But whether it should be maintainable or not, it need to be decided.
That's why I'm saying what my learned senior friend has submitted before your lordship. There is no violation of Meghalaya High Court rules.
Oof.
My
this is too much.
Friend has submitted that there is a violation of Meghalaya High Court rules.
Correct.
Whatever they are saying in their my lord submission, those aspects were clarified in my affidavit in reply.
So you have clarified. That's your argument.
My
That's
lord.
your submission.
My lord.
You are referring to a judgment of the Supreme Court, Jharkhand High Court, which according to you has been confirmed by the Supreme Court.
My lord.
The Jharkhand High Court has considered the rule pertaining to public interest litigation.
My lord.
Correct?
My lord.
Whether it is the Jharkhand High Court rules, the wordings in the Jharkhand High Court rules and the Meghalaya High Court rules are one and the same. Is it pari materia? That is what we are asking.
My lord.
No, my lord. There is a provision in
Mr. Mishra, 1 minute. We'll ask you.
Exact, my lord, I have to, my lord, match, my lord, both the provisions. That I have to do, my lord. Both the provision I have to.
The exceptions are
If it
there.
is not pari materia, then nothing bar from you from withdrawing the writ petition, file a fresh writ petition in conformity with the provisions of the Meghalaya rules.
Otherwise, also, my lord, the objection, well, very small objection, technical objection being raised. Those are not bearing with the merit of the case. They are saying that I have not disclosed my credential and all. What I am. Those are those
things may be material, may not be material. That's different. You see whether it is in conformity of the rules or not. If it is in accordance with the rules, we'll say, if you say that it's pari materia, and the Supreme Court has confirmed this in para number 64 or whatever you say, then we'll ask Mr. Mishra to clarify how is he going to overcome the decision of the Jharkhand High Court, how he is going to discuss.
After 16, any date may be given, but in the meantime, I will, my lord, go through it.
But my lord, he is here. Kindly give me the papers which you are submitting before in court.
No, now he has handed over to, Mr. Mishra, he has handed over to the counsel on record here. So please check the pagination numbers. Post during the first week of June. The request of the petition. Today, additional document has been produced. Additional document pertaining to so-and-so has been produced before this court. Copy has been handed over. Senior advocate has reiterated his submission, which was made earlier. That writ petition itself is not maintainable and is not in conformity with the Meghalaya High Court rules. The counsel appealing for the writ petitioner submitted that similar objection was taken by in the Jharkhand High Court. And the said judgment is reported in 2022 SCC online Jharkhand 1489 para 109, and the Supreme Court has answered, and the Jharkhand High Court has answered for the said objection that the public interest is maintainable and that on technicalities PAL cannot be thrown out. Stop. He also further submitted that the decision of the Jharkhand High Court has been affirmed by the Supreme Court. Decision reported in 2022 SCC online SC 1541. The senior advocate appearing for the respondent, seventh respondent, will submit that the litigation has been converted into public interest litigation and that this court shall not entertain writ petition of this nature, which has got to be redressed in case the petitioner has got any grievance before a different forum. He also further submitted that a copy of the document now circulated before this court has not been furnished to the counsel on record. Taking note of the submissions of the both parties, we are inclined to post the matter on so day, 3rd or 4th you post it.
Except 3rd, my lord. On 3rd I have some difficulty, my lord.
When do you want? 4th?
4th, 5th, your lordship.
5th June.
But on that day, your lordship,
Prepare a simple note of your submission, which should be not more than 2 pages. Should be enough. And the short note should contain in one line your submission and the pagination, the page number of the typeset of papers. So that by referring to that, you can easily see that. So you are finding about 1,000 pages. And it's also not... in fact, we have to also bring the paperless court. Only then it's good.
My lord.
I think we are going to start that in Supreme Court. Anybody is having the application liquid test?
Lordship, I am using it.
I
am using it.
You are also using?
Completely migrated to liquid test. 100%.
But in fact, I wanted to have a session with regard to usage of liquids. In fact, I was talking to my brothers.
Any day, Lordship.
So that one day it will be easy. So those who are practicing, it will be very good. By click of a button, you can go to the relevant page.
Absolutely.
My lord, in this matter, my lord, CBI and Enforcement Director have raised party, my lord. Now, CBI and ED, like, we don't have anything to say, my lord. It is for Lordship to decide whether any inquiry is required or not.
We'll see at that stage.
But then what is foreign from a Lordship? That is the crux of the issue, whether it's parameterial.
Sir?
What is foreign from a Lordship? Whether the Supreme Court judgment of Jharkhand High Court rule is parameterial with...
That's what we have said. That's what we have said.
And there will be two consequences. If it is parameterial, then the matter ends. If it is not,
then we can withdraw him. That's what we said. He'll examine and report the next hearing.
Absolutely.
See, we are not going to foreclose you from a... You can withdraw it and do comply with it and file it. Whether that petition PL is maintainable or not, it is for the others to argue.
And then this Honorable Court can say it's a parent curiam judgment so far Jharkhand High Court is concerned. And he has the liberty to withdraw.
My lord, it's a 40-page petition, my lord. They can easily withdraw it and refile it as per the format of Meghalaya High Court, my lord.
Anyway,
it's not a bulky thing also.
Let him get monetary instruction from his client.
My lord. Lordship will only grant that much time only for monetary instruction, my lord. Next day he will withdraw, my lord.
Yes. 5th of June.
My lord.
See, answer the no purpose.
I will prepare my lord court note and I will see my lord Jharkhand High Court rules also.
Lordship is summed up the crux of the issue, so it won't take much time.
You understood the matter.
Absolutely.
That is why we have said we asked the senior Mr. Mishra not to address because we are still not agreeing with his contention.
My lord, a businessman filing a PIL against some other business, my lord.
That is why he said related. That is why before all of you started addressing, I asked him whether he has got any personal interest. Everything, all questions the court has posed.
In my reply, my lord, I have answered everything. There is no personal.
Sir, first of all, you must cross the first stage.
In fact, in PIL, I have given my details because, my lord, earlier also I have filed PIL and this Honorable Court has passed a number of orders. And in
we are not on that. Whether you have done it in accordance with the rules, please tell us. And whether the decision is on parameter, the rule is parameter with the other rule. That's all. That is the thing you have to address.
Will do. Deeply.
We are not saying that don't file it. You withdraw it and file a fresh case.
Deeply.
That I can do today also.
See, insofar as the public interest litigation is concerned, and so far as the matrimonial concern is concerned, there is no question of adjudicator. As and when you get a fresh material, you are entitled to file.
Here, this case, my lord, if your lordship will enter into merit, your lordship will find, yes, this is a real public interest, and your lordship will like to exercise, my lord.
There is nothing in the merit. Nothing in the merit. Will not stand even 5 minutes.
Deeply obliged. On 5th, my lord, I will satisfy. I will bring my 1-page note also, my lord.
Yes, with the relevant pages.
My lord, will do.
Before giving that, you must convince us that this is parameteria.
True, Your Lordship. I will bring my Jharkhand High Court rules, Meghalaya High Court rules, so that Your Lordship will also see it is parameteria.
That is the only legal issue involved. Lordship, absolutely correct.
The wording may be different, but the rules going to give the same meaning. Then we can say it is parameteria. Otherwise, we can't say.
Otherwise, Supreme Court judgment will be per inquiry. So far, Meghalaya High Court rules are concerned.
Rule 6A itself differentiates. There is an exception. Even the Supreme Court has said, while setting aside the Jharkhand High Court order.
Yes.
That I'll play.
Yes.
1/5.
Item number 4.
March 2024, my lord, I was not able to appear before this honorable court. My colleague had appeared before this honorable court.
Yes.
And my lord, the counsel for the respondents, my learned seniors, they had submitted that some documents have been forged and filed before the court, and that based on the enormous proceedings conducted by the court, it was found that the documents were forged. Now, my lord, that...
Sir, please mute your mic, sir. Some noise is coming. We are not able to concentrate. Yes.
So, my lord, in my humble submission, my lord, this particular forged document issue was never raised in these 3 appeals.
No, this came up on 9/4/2024.
9/4, my lord, I had appeared, and the affidavit of service was recorded. The order just prior to that, my lord, 19/3.
19/3.
19/3, my lord. I was not able to appear, my lord, on that day.
15/12/2023.
Lordship will see 19.
My lord, 19/3/2024.
19th
In WA 50, my lord. It is
19th March.
It must be at the bottom, my lord.
9/4.
My lord, 19/3 should be at the bottom, most probably.
No. It's 19/3. That is taken from the counsel appearing the evidence submitted responded by not served and it shall bear evidence so before the court based on the erroneous proceeding conduct with the court documents were forged. Preparing not challenge the termination. Yes.
My lord. So, my lord, to this effect, I have taken instructions from the appellant herein. So far as the forged documents are concerned, my lord, those were not with regard to the writ petitions against which the writ appeal have been filed. That particular allegation was made or submission was made with respect to WPC 119 of 2022, my lord. 119.
You are not a petitioner.
My lord, I was the petitioner in that particular matter, but my lord, we have also filed a rejoinder. It was the school managing committee which was the petitioner, and I was the convener of the school managing committee. At present, I am no longer the convener of the school managing committee. And your lordship had also indicated that since it was a common judgment passed, the records of the other writ petitions may be called for if required. So, my lord, in my humble submission, my lord, the records of WPC 119 of 2022 may also be called for, because the state government had filed an affidavit in that matter. After filing the affidavit in opposition, it withdrew the affidavit, thereafter filed another affidavit, and to that fresh affidavit, the petitioner had filed a rejoinder as well. Now, my lord, since the issue involved in that particular writ petition had become infructuous, as such, no writ appeal was preferred by the appellant. And the second reason is the appellant was no longer the convener of the managing committee. So he could not have filed the writ appeal on behalf of the managing committee. So, my lord, that is the reason in my humble submission, the records of WPC 119 of 22 may be called for. Because when that writ petition...
WP number 119 of 2022.
My lord.
The two papers pertaining to 2 cases have got to be called for. 119 and 2022 and?
Only 119 of 2022. There were a total 7 cases, my lord, which were disposed of by the common judgment. In 3 cases...
No, only 1 appeal is filed.
3 appeals have been filed, my lord.
No.
Serial number 5, 6 and 7. 3 appeals were filed. Because the appellant was aggrieved by...
Case numbers? 50?
My lord, 50, 51 and 52.
Yes.
So all the 3 appeals have been filed, my lord. The writ petitions
What is the relief sought for the writ petition?
My lord, I'll go one by one, my lord. So far as writ appeal 50 is concerned, I was the private respondent in the writ petition, and the respondent number 1 in the writ appeal was the writ petitioner. And the writ petitioner was seeking the relief claiming salary. Whereas, my lord, I stand, the managing committee as well as the private respondent number 4, the appellant stand before this honorable court was that the writ petitioner had already been terminated from service way back in 2017, and that particular fact was not mentioned in the writ petition. The writ petitioner had suppressed the facts. And the government also came up with a stand that the writ petitioner was not occupying a sanctioned post. So, my lord, that was the submission, that is the crux of the matter in writ appeal number 50. Now, my lord, coming to writ appeal number 51, my lord, in this particular writ appeal, my lord, I had challenged the appointment of another private respondent, that is Srimati Shobuza Begum, on the ground that she had been appointed by the managing committee, but that particular managing committee constituted of, my lord, 11 members, as far as I remember, my lord. Lord, the majority members were the family members of the private respondent who was appointed. So on that ground, the writ petition was filed and no advertisement was issued prior to the appointment of the private respondent. She was simply replaced by the retiring teacher or the teacher who was leaving the office. So there was no proper selection procedure followed. Challenging that, the appellant came before this honorable court by way of a writ petition. And so far as writ appeal 52 is concerned, my lord, in this particular matter, the writ petitioner had filed a petition being WPC 147 of 22, claiming his salary which he had not been receiving for the past, almost 2 to 3 years.
For having rendered service?
Yes, my lord. No salary was being paid. That is why this writ petition was filed. And in the impugned judgment, the learned single judge has allowed salary only to the 2 private respondents whom my learned friend Mr. S. Deb is representing. So this writ appeal number 52 is for prayer for salary, my lord, release of my salary since I was rendering service.
So you have not been paid salary?
No, my lord. And now, my lord, when the inquiry was conducted, this honorable court had directed an inquiry to be conducted by the Education Department, my lord. The Commissioner and Secretary of the Education Department had conducted an inquiry. After the inquiry was conducted, a copy of the inquiry report was submitted by the government advocate to the court, my lord, with due flag marks and everything. But, my lord, in spite of oral prayers, my lord, I will honestly submit this. It was a verbal prayer before the court that we may be provided with a copy of the inquiry report so that we may submit our response to the same. But no copy of inquiry report was provided to us, which amounts to gross violation of principles of natural justice as has been held by the Honorable Supreme Court, my lord. So my limited
This is not a domestic inquiry.
It's not a disciplinary. It was not a domestic inquiry, my lord.
Inquiry.
But, my lord,
pursuant to order of the court, it has been done.
It was, my lord. But
copy will be produced before the court.
My lord, produced before the court.
It was given in sealed cover.
It was not in a sealed cover, my lord. It was not in a sealed cover. The order sheets, my lord, I can produce before this honorable court.
If I may please, your lordship, I appear for the original writ petitioner.
If I may just be permitted to complete, my lord. But I may place the order sheets, my lord. Lord, if I may take your lordships to order dated 25/7/2023. If I may read, my lord. Report as directed by this court, wide order dated 22/5/2023, asked in Miss Case number so and so, in WPC number so and so, has been furnished by Mr. K.P. Bhattacharjee, learned GA for the state respondent. The same is taken on board and to be examined. Mr. K.P. Bhattacharjee, learned GA for the state respondent, to flag the relevant portions of the inquiry report and produce the same within 1 week. List this matter on 9/8. The next order is 9/8. A copy of the inquiry report conducted by the Commissioner and Secretary to the Government of Meghalaya Education Department has been flagged and paginated by the Government Advocate and has been submitted in the court today. The same is taken on board and made part of the records in original. My Lord, if the learned Government Advocate is flagging the inquiry report and is paginating the inquiry report and then submitting before the court, how can it be called to be a report submitted in sealed cover? It cannot be in a sealed cover.
Originally it must be in sealed cover.
It was not
opening, they would have given it. Whatever it is. You see, now it has been produced before the court.
My Lord.
If you want, you could have asked for the court, you requested the court, or you should have applied for a copy of your proceedings.
My Lord, on that particular day, the copy was furnished before the court. Matter was listed on 29 August for hearing. If I may take your Lordship to the order dated 29 August, that is the last order, my Lord. Last page. Matter has been taken up today for hearing as the same is substantially heard on the last occasion. Hearing concluded, judgment reserved. My Lord, without hearing on the inquiry report, how can the judgment be passed completely on the basis of inquiry report when I make a submission before the court that we need a copy of the inquiry report to examine the same?
Proof that you have demanded.
No, that is the entire crux. In the order also it is not recorded. I have not applied in writing because, my Lord, there was, your Lordships are dealing with a matter in the full bench, the coal mining matter. Every single report, my Lord, that is also a court-directed inquiry. It is not a domestic inquiry. Every single inquiry report is provided to the
litigation. It's a duty cast upon us to give a copy.
My Lord.
So in some cases we may give, sometimes we may forget. At the time you was also remind us to give a copy.
I did, my Lord. Verbally, I did, my Lord.
Okay, we take the verbal request.
My Lord, this is just, in my humble prayer, my Lord, this is the trust between the bar and the bench. And I am making this statement on the basis of the fact that I myself was appointed for the learned single.
We are not saying that we are not trusting your word. But we cannot take that word now because you have addressed that before the learned single judge.
We paid for a copy of the inquiry report.
Judges at that point of time hearing the petition.
My Lord, had the copy of inquiry report been provided to us, we would be in a position to submit a response to the same. Now, my Lord, I admit that I had appeared before the inquiry officer. I had submitted all the documents which were relevant before the inquiry officer. But, my Lord, I need to know whether the same has been made a part of the inquiry report or not. My Lord, that much, my Lord, right, my Lord, we do have. Because copy of inquiry report was there. But we have not received it before the judgment is passed.
Then you withdraw the report, final review before the learned single judge. You are requested for a copy of the order verbally. It has not been produced. You may furnish a copy, review the order, seek a review. That is all. We cannot go to.
My Lord will kindly appreciate one fact, my Lord. This particular appellant is facing extreme trauma. For the past 3 years, he did not receive his salary.
We have already passed an order saying that if you say that you have not made a consent or you made a request, your remedy is by way of a review before the same judge. If the judge is not there, it's a different thing. Still, you have to go before the another single judge. But we, in the division bench, we cannot take a decision. You file a review, we'll give you a liberty to file a review. That is all. Then if you are agreed, you are entitled to file another appeal.
Lord, if I may be just permitted few minutes time to seek instructions, I will not delay the matter unnecessarily.
We'll give you liberty, you file an appeal or file a review.
But my Lord,
all the three are connected, is it not?
Yes, my Lord. All are. My lord, actually it relates to the same school. The issues are different in every single writ petition.
So according to the issue now you are canvassing is only with regard to 50.
No, my lord. All the three.
All the three matters.
All the three matters, my lord. Because one relates to salary being granted to a person who has been terminated from service in 2017.
The inquiry report has nothing to do with the salary, is it not?
My lord, inquiry report has got to do with the salary, my lord.
Then we have to file 3 reviews, that is all.
My lord, even if we get inquiry report in one of the matters, it will be sufficient.
That is right. Still, it has got to be then you will have to address all the 3 writ petitions for the learned single judge.
My lord.
Review is entertained. When copy is given, writ petition is stored on file, writ petition will have to be argued. You cannot argue the writ petition before us.
No, writ petition definitely cannot be argued.
Exactly. It has got to be, once a review is accepted, writ petition will be taken upon, writ petition will be heard by the single judge and orders will be passed.
My lord.
Get instructions.
My lord. Obliged.
We'll post it tomorrow, but you have to come all the way from.
My lord, if in case my client instructs me to get it withdrawn, I will appear virtually and I'll withdraw and subsequently I'll file a review, my lord. Virtually I'll make the submission.
Otherwise, we are not agreeing with you.
My lord, I got some decisions, my lord. Though right now I don't have directly on the issue.
The question of principles of natural justice will apply only in the domestic proceedings. In this case, you got an opportunity, you are not availed. The proceedings have been conducted pursuant to orders of the court.
My lord.
Now you are making allegations against the court. Indirectly, you are making allegations against the court.
That is only one of the grounds, my lord. There are other grounds as well in these writ appeals.
Suppose we agree.
My lord.
The other way you give up that point, inquiry report point, you give it up.
My lord.
You give it up. Then we'll take into account the inquiry report. If
yes,
that is valid,
my lord, since after filing of the writ appeal, I went through the orders again. So at that point of time, I saw that the inquiry report has also been taken on board. So the inquiry report is also before your lordships now. I have filed it by way of an additional affidavit. So my lord, a date may be fixed and the matter may be heard on merit.
You are willing to hear. You must understand one thing. You must understand one thing. That we will go based on a submission and the inquiry report. We will not say that the inquiry report was not given to you, hence that is bad. That finding we will not render.
My lord, that ground, my lord, it may be recorded in the order as well. I will not argue on that particular ground. I will argue completely on merits, my lord. But if your lordship will kindly give me one liberty, my lord, that I may be permitted to file an affidavit on the inquiry report. On the inquiry report. The inquiry report has already been taken on board. I may be permitted to file an affidavit with regard to what my submissions are with regard to the inquiry report.
But you accepted the inquiry report.
My lord, inquiry report, I applied for an uncertified copy before the registry and thereafter I have taken the uncertified copy. And this inquiry, the entire judgment is based on the inquiry report. So once the judgment is under challenge.
See, there was no objection before the learned single judge. How can you object it now?
My lord, when the inquiry report is not in our
hands. That is the reason why we are giving you a chance to say that you take up by way of a review. We will not permit you to file an objection now. The finding of the learned judge is contrary to the proceedings may be accepted. You can't say completely brush aside the inquiry report, which we do not agree. That you have got a right only before a single judge, not before the bench.
But then I may be permitted to just seek instructions within 2 minutes, my lord.
Yes,
just one phone call.
Get instruction. Yes, call the next case. This is the last case. Huh? Okay, get instructions. We'll wait. Suppose we allow this case, not continue, but letting or down or here. See, after this matter, ask the bar representative to meet us with regard to the liquid text. Lawyer is here.
I'll call.
So we'll ask them to tell them how it can be used by the lawyers and also by the staff. Registry.
I do not know whether the president is. Oh, right. He was here. He was appearing before your lordship.
Ask him to come now.
Lordship.
Ask him to come so that we'll
then,
fix the date.
Secretary General, I'm not aware, your lordship, whether she's here or not.
Which you are not aware?
I'm not aware whether she's because she was on leave. I don't know.
Ask them to be here.
Lordship, I'll inform them.
Ask them to come now. So we'll be here in the chambers and we'll tell them how the purpose. See, Chief Justice of India is very particular that we must have a paperless court.
Shall I call them now, your lordship?
Yes. Now it's in the chambers. Will come to the chambers. So that both of us will be there. What is the purpose of using the
lordship?
It will be very, very useful. Yes.
My lord, I pray for liberty to approach the learned single judge to file a review on the ground that the inquiry report was not provided.
The counsel appearing for the appellant has made the various submissions. And one of the main submissions is that a copy of the inquiry report has not been furnished. And the same is in violation of the principles of natural justice. We are not in a position to agree with the said contention, as it is not a disciplinary proceedings wherein a copy of the inquiry report will have to be furnished, comments to be called for, and thereafter a decision should be taken. The report has been produced before this court pursuant to the orders of this court to conduct inquiry. Stop. Though the counsel appearing with the appellant would submit that the report has got a bearing on the three matters, and that though she has made a verbal request for a copy of the report to be furnished, we are not inclined to accept the same in this appeal. It is open to the writ petitioner, appellants, to file a necessary review petition, if so advised, before the learned single judge, putting forth the submissions. Full stop. Along with any other submission which may be, which may or can be reviewed, or which can be accepted for the purpose of review. By giving liberty to the petitioner appellant to approach the learned single judge by way of review, we make it very clear that it is for the learned single judge to decide the issues, including the maintaining of the review, in accordance with law.
My lord, this period of limitation, my lord, the writ appeal.
Naturally, it will go. The period during which writ appeal is pending is necessarily to be excluded for the purpose of computing the limitation for filing the review. All the three.
All the three, my lord.
That is why we asked her whether the other two matters have got any bearing with regard to the report. She said everything has got
the same judgment.
Same judgment. It's a common judgment. There were 7 writ petitions, your lordship. There was also an order passed by the Honorable Court, by the learned single judge, your lordship, which was not placed before your lordship. Why the inquiry is necessary, your lordship? Because
that is also part of it. It's just that I did not go to that part.
That is right. See, disposed of. You say disposed of with liberty. You say disposed of with liberty. Oh, sorry, withdrawn with liberty. Dismissed as withdrawn. Dismissed as withdrawn with liberty to the petitioner to approach the learned single judge for filing a review. You make an endorsement that you are withdrawing the appeal with liberty.
Yes, my lord.
Make an endorsement.
And
that is enough. Withdrawn with liberty. So we have passed a detailed order.
Yes, my lord. The order, since it's recorded in the order, my lord. If
generally in Madras, we insist that withdrawal. We insist that. So tomorrow somebody should not appear and say that we are not withdrawn.
Indeed, my lord. But my lord, nowadays one benefit, the entire streaming is on YouTube, so.
He's right. That cannot be taken as evidence at all.
My lord, that is true.
No, artificial intelligence, everything is coming.
My lord.
Somebody else.
Yes, my lord.
Advantages are there, disadvantages are there. Yes. What, brother? Why are you waiting?
Lord,
I was appearing for respondent number 4 and 5, Lordship.
Lord, private respondents were there in writ appeal number 50, so he's appearing for them.
Yes. Obliged.
Much obliged.